Good afternoon, ladies and gentlemen, and welcome to today's webinar, State Government Information and the Copyright Conundrum, brought to you by NCSL. All lines have been placed on a listen-only mode to provide favorable sound quality during today's presentation. It is now my pleasure to turn the floor over to your host, Sonia Gavin. Ma'am, the floor is yours.
Welcome, everyone, to today's webinar presented by the Legislative Research Librarians and the Research and Committee Staff sections of NCSL. Unlike federal government documents, which are almost universally in the public domain for the purposes of U.S. copyright, state government documents receive copyright protection by default. Despite this current default, many state agencies view their documents as being in the public domain. The consequences of the divide between the legal default and the perception of state agencies is a significant impediment to institutions seeking to digitize historic state publications, capture and archive-born digital publications, and freely disseminate these materials to the public via library catalogs or digital repositories. Our speakers today are Bernadette Bartlett from the Library of Michigan, Justin Bonfiglio from the University of Michigan Copyright Office, and Chris Kasanovitz from Stanford University.
Hi, I'm Bernadette. I am the Michigan Documents Librarian at the Library of Michigan. I am often approached by coworkers, fellow state employees, members of the public, and other libraries with questions about copyright and Michigan state government information. So I have been investigating this issue for several years. I recently completed an online course on copyright from Harvard Law School, and I've been compiling a record of how the state of Michigan has addressed copyright of state government information in law, rule, and policy.
And my name is Justin Bonfiglio. I currently work as the Copyright Specialist Librarian at the University of Michigan Copyright Office. I have a JD from the University of Michigan Law School, and I work with with Michigan's Copyright Review Management System, which is a project funded by a grant from the Institute of Museum and Library Services. Our mission is to determine the copyright status of works found in the HathiTrust Digital Library, a digital library which currently holds over 11 million total volumes. And when legally permissible, we work with HathiTrust to open public domain works and make them available to online users.
And hello, my name is Chris Kasanovitz. I'm the State, Local, and International Government Information at the Stanford University Library. I've worked with state and local government information in an academic library setting for about 18 years or so I've had a lot of experience with these materials from a research and collection management standpoint. I've seen marked increases in the multi- or 50-state research realm, and I'm constantly running up against the issue of copyright with state government information, which has been in some cases an impediment to access. So I've decided to take action and tackle state and local copyright issues for the global good of access to government information. And I just want to point out we're big fans of state government information in the academic world. All right, so thank you, Sonia, for introducing us, and welcome everyone. These are the broad topics that we're going to talk about today. As you can see, we have a pretty full agenda. So we want to encourage everyone to use your chat function to ask questions throughout the webinar. We're going to hold responses to questions to the end because we're hoping to have about 10 to 15 minutes of Q&A. So I hope that works out for everybody. Okay. This is our inaugural presentation by our group, Free State Government Information. And as a group, our initial goal is to raise awareness and get a dialogue going with all of you in state government. We have a lot of ideas and solutions, but we really need to collaborate with you all to bring about change. And so to that end, our outcomes for this particular session are meant to help us get the ball rolling on this project. And so just to kind of recap, this quote from Margaret T. Lane, who authored a book called Selecting and Organizing State Government Publications, really kind of captures the issue that we face in libraries when we're managing and providing access to state government information, and especially that are in ways that are meaningful to our communities. And just want to point out, we've put an asterisk next to right because, as you heard in the introduction from Sonia, under current copyright law, all materials are copyrighted whether or not the state agency actively copyrights the work. So it basically, you don't have to have a copyright mark on those publications. They're automatically copyrighted. So this basically sets the stage for why we're all here. Next, I just wanted to briefly go over the survey results. I wanted to thank the 32 people who were able to log in and respond. We really appreciate it. This helped confirm some of the ideas that we thought you would, this confirms some of what we thought about copyright with state agencies. And as you can see, a lot of people don't know if there is existence of copyright in their states. So this is something we also face in libraries. So again, we were glad to see how some of these results turned out. And it's also interesting to see in terms of top concerns for public domain that authenticity and control over the publications are top on the list. And working with federal government information, these are also two of the big top issues. Also, I was pleased to see that a lot of people felt that publications should never be copyrighted. So that'll be an interesting point for discussion later. Okay. The last, another thing I want to go over is just to clarify what we're talking about. We're talking about publications. And you may hear us refer to this as state government information, state government publications, or state documents. Sometimes they're even called records, but what we're talking about are things that are published and distributed, print or online for the public's consumption. And these are some of the items that we see grouped as publications in that tag cloud. Okay, oops, excuse me. Okay. And then again, just a quick and broad overview of copyright for our purposes, and Justin's going to unpack these issues more in his section. But the next two slides provide you an overarching, provide the overarching policy and legal environment in which we operate. So federal government, simply put, is not copyrighted. It's got Section 105 that clearly states this. So everyone has a clear understanding of what they can do with a federal government publication besides just access or look at it. However, at the 50 states, copyright's a bit of a conundrum. States may have their own copyright laws, and as we saw from the survey responses, the majority of us do not know if one even exists. Nowhere in the federal copyright is there any mention of states, so the same copyright restrictions for, say, a work of fiction are going to apply to state publications. So how does this copyright environment affect those of us in academic research libraries? While I'm currently employed at Stanford, I've had the same issues while working at other universities, and I know I have colleagues at other libraries who have experienced this. So I feel that what I'm saying can be fairly generalizable across academic institutions. Libraries have been collecting state publications for years. Many states have state depository programs that distribute publications to libraries. At Stanford, we are a California State Depository, and our collections are really quite good, having complete sets of the California statutes from 1849 forward, as well as many agency reports dating that far back. But we also have very rich collections in print from all 50 states. We're not a comprehensive 50-state library, and I know that there are libraries out there in the U.S. that are. But we tend to have the major legislative, judicial, and executive agency publications often back to the start of a state agency's first publication in our collection. These materials, in our view, have really high research value, so we hang on to all of them. We don't weed them and get rid of them. And of course, we are also grappling with the collection of born digital materials, and that's a talk for another time, but that's also on the forefront of what we're dealing with. In the academic research world, data is key, and sharing one's data is becoming a very standard practice as well. Data enables our researchers to develop and test hypotheses, to write their dissertations, scholarly articles, policy briefs, reports. In the current digital environment, almost anything can be data for researchers: tweets, Google ads, even entire collections of websites. So for a graduate student to conduct research with data that nobody else has used before is a big deal. They are creating new knowledge with unique data. And this is how we see the content of your state publications. All of the textual and tabular information contained inside your state's publications is the next big data frontier. With the ability for us to scan or digitize print publications and then OCR the text, entire runs of state publications become a corpora of text and numbers that can be mined, mapped, analyzed in so many different ways. Having online access to the born digital publications enables a researcher, once they've scanned the print, to assemble an amazing longitudinal data set from which they create their new knowledge. But use of state government publications doesn't end here. In addition to data, the issue of data curation is of utmost importance. This term of art involves the archiving of one's research data in a digital repository. This is driven in large part by the requirement of federal funding agencies that authors not only make their article or report broadly available, and you may have heard some of this discussion in open access arenas, but to also make their data available as well. More and more scholarly journals are requiring authors to deposit or make their data available somewhere as well. In the university setting, libraries are grappling with ways to support these mandates and thus have taken on the role of building digital repositories where faculty and students can archive their data and make it widely accessible. So not only are we helping researchers assemble their data sets, we're also helping them manage and access it for the long term. And so, just grab my pointer here. So here's an example of what the data collection side looks like when our researchers want to use state-level government information. These are catalog records from Hathi Trust, from Stanford, and then UTA. So this is the discovery environment that our researchers will find state government information. Typically, the online versions will be found in Hathi Trust, and as you can see in this example, there's several years that have a full view. They may also find materials in Google Books. And what they'll do is they'll download those full views and see the scanned versions or portions of them makes them feel like, well, we can get all of this in an electronic format. So they also figure that since that state publications are not copyrighted just like their federal counterparts, so those, when they come to seeing these holdings like this in Hathi Trust, they're already approaching it with this is already in the public domain, and seeing these limited views is merely just kind of a technological glitch, or someone hasn't yet flipped the switch to open them up, and we just need to ask to make that happen. However, Hathi can't really open up the scans unless the agency gives them permission to do so. And Justin's going to go over this in more detail, but I want to point that out because this is important for our conversation. Often entire runs of a publication are not in Hathi or have not been digitized. So then researchers are going to turn to other library catalogs like ours, SearchWorks, or say UT Austin, to locate the print issues to collect a complete run of a particular publication. And so what we do is we'll help them assemble as complete a run as possible. We'll request materials on interlibrary loan and bring them all together in one place. Then the next step is that we're going to get a request from our researchers to scan the print material. And it's precisely because of the copyright nature, our general counsel here on our campus requires us to seek permission from each state agency. Because once we scan the publications, we add links to the PDFs into our catalog, and that's why we've got to get permissions. And so on this slide, you can see an example of the language that we send out to a state agency. This is for a project that I'm assisting 3 faculty with, and then we're working only with 9 states, so it was a little bit manageable. And we were able to obtain permissions from each of the state's banking agencies. But it took about 3 months to do this. And so you can see the language that we send them. If you look at the language, it enables us to put the scanned publications into our digital repository and make them accessible, just like books in the stacks. I've worked with other projects that initially started out of wanting to do a 50-state survey. utilizing the rules from the legislature, from both houses, all the way back to the beginning, and we had to significantly scale that back. In fact, that researcher ended up only using 12 states because it was taking over a year to try and get permissions and manage that whole process. So for our researchers, while they get copyright and what it's trying to protect, this is a long, arduous process of seeking permission agency by agency, title by title, to either reformat, digitize it, or download it from a website for materials they really feel and hope and wish were in the public domain, or at the very least could be used for research and publication in this way. Having clear policies, even some type of statement on publications explicitly stating how the material could be used, would be very helpful to us. All right, so now I'm going to turn it over to Justin, who's going to give you the digital repository perspective.
Thanks, Chris. So I'm here to give you some perspective on copyright law and state government documents as we see it in our work with the HathiTrust Digital Library. And as I mentioned earlier, HathiTrust holds 11 million volumes, and our daily work involves determining the copyright status of its collections. And this often includes both state and federal government works. As Chris has mentioned, there's a divide between state and federal government documents when it comes to copyright law, and at the foundation of the divide are these two provisions of the U.S. copyright statute. Under current U.S. copyright law, copyright protection subsists as soon as a work is fixed in a tangible medium of expression. So practically what this means is that a government document is protected by copyright as soon as it is created. However, as you see in Section 105 on the right, the vast majority of federal government documents are not protected by copyright in the United States, and they are instead through the operation of Section 105 in the public domain in the United States. Translated into the digital library context, this means that we have public domain federal government documents, which we can confidently make available in digital libraries today, but we frequently don't have that same level of confidence with state government documents. And without some change to a state's laws, a state government document published today will receive 95 years of copyright protection by default and will not enter the public domain until 2110. And in the next slides, I'll try to flesh out this issue as it relates to state government documents. Here's some visual context for some of the types of state government documents which can be found in HathiTrust. The work on the left, I'll use the pointer. This work on the left is a banking report from the state of New Jersey, which was published in 1918. And this particular work is in the public domain because it was published in the United States before 1923. We worked with Chris to open a set of banking reports like this based on whether or not they bore a copyright notice, which was a formal requirement of U.S. copyright law for much of the 20th century. So those works that didn't have a copyright notice, we were able to open some of them even if they were published after 1923. The work on the right here, is a publication of Michigan's Department of Education, which was published in 1976. And unlike the pre-1923 banking report, the Michigan Library Directory is available online through a collaboration with Bernadette and the State Library of Michigan. Through their combined efforts, a Creative Commons Zero license was applied to this particular work. And just to give you some context on a Creative Commons Zero license, it essentially says that this work has been dedicated by the rights holder to the public domain and that it's not protected by copyright and may be reproduced and distributed freely without permission. When we talk about state government documents, we're also interested in the state's codification of the law. And here are two state government documents, an annotated code from Iowa and compiled laws from Michigan. And these are both public domain works because they were compiled and published in the United States before 1923. But as you all know, annotated codes like this continue to be created and published today. I want to highlight annotated codes in particular because there's disagreement as to whether or not these types of state government documents are in the public domain. This slide is a selection from a cease and desist letter that was sent from the Mississippi's Attorney General's office to public.resource.org, a website which hosts annotated codes similar to those we looked at in that last slide. And no matter what your feelings are on this particular issue, we do know that some states currently take the position that their annotated codes are in copyright and may not be made freely available online. And we know this because public.resource.org has received cease and desist letters from a number of states, including Idaho, Mississippi, and Georgia. And all of these states have asked for their state annotated codes to be taken down from the website. Carl Malamud, the founder of public.resource.org, has taken the position that these annotated codes represent the law of the states and that people should be able to access the law anywhere. And he points to a long history of court decisions, including the Supreme Court in Wheaton v. Peters and on through Vec versus Southern Building Code, which is a Fifth Circuit case decided in 2002. And in those, the courts have essentially said that state and federal law is in the public domain and should be freely available to its citizens. In some states, many of which have contractual relationships with for-profit publishers, for example, take the position that the annotations to these codes are still protected by copyright, no matter what the status of the underlying statutes. If we follow this line of argument in a digital library context, the work has to remain closed, and in most cases it's impossible to separate the annotations from the code, so the result would therefore be that the entire work, statute, and annotations combined would be closed in the digital library. What we find in states that do address this issue, typically we have the problem we face is that state statutes don't directly address copyright. Instead, in many states, we've seen statutes like this one that I'm displaying now, which is from North Carolina, that refer to public records but do not explicitly refer to copyright. And so when I look at this particular statute, I ask myself the question, does this statute disclaim copyright in state government documents? And I'll say that I don't have a great answer to that question because we've worked with librarians in North Carolina who strongly believe that this language from this statute means that state documents in North Carolina are in the public domain. And while I don't think that they're necessarily wrong, when I read this language, I see a commitment to providing access to state government documents via state government agencies, but I don't necessarily see a clear signal that North Carolina doesn't claim copyright in state government works. And I don't want to get bogged down on this particular slide, but I do want to provide it as an example of an area where clarity can be elusive for us. In some cases, state governments are trying to address the copyright, but I want to highlight some of the difficulties in the proposed language I've seen. On the left-hand side, again, you see 17 U.S. Code Section 105, which rather simply says that U.S. government does not claim copyright in works of the U.S. government. But on the right-hand side, you'll see a proposed bill from New York, and if this language had been enacted, I personally think it would have been hard to implement. As you can see, the bill's language waives copyright, but then it also has a series of exceptions that I've tried my best to highlight for you. Reading the language, I imagine that it would be difficult to determine if some of the exceptions apply to a particular state government document. For example, one that includes a series of photographs. Would that series of photographs reflect artistic creation sufficient to trigger the exception? Many of the state government documents we encounter feature elements that might trigger the exceptions listed here in this proposed bill. And compounding the issue is the reality that agency intent often isn't entirely clear to us. So looking at a specific document, it can be hard to tell if the state intended to sell or rent or license the work. And this lack of clarity can be a stumbling block for users and for digital libraries, if for no greater reason than we work with a lot of documents in digital library context. This slide is the last slide I have that relates to the copyright issues and the current legal landscape that I want to talk about in this portion of the talk, but I'm going to hand it over to Bernadette, who will speak to the state government perspective.
Hi. I did want to introduce some information about the perspective of state government to follow up the issues and the challenges that Chris and Justin have highlighted with their research and use of state government information. And I do also want to say, though, that I'm speaking strictly from my experience with Michigan state government, but I do feel that there are similarities across state governments that make this perspective relevant to your state as well. The biggest stumbling block I feel in state government agencies is that agencies and employees do not truly understand or are simply unaware of copyright and its impact on state government information. And when I say they don't understand copyright, that includes the concept of fair use and public domain. And that causes a lot of assumptions and misperceptions that block users from getting the access or permissions they need. One assumption is that state government publications are already in the public domain and users do not need specific permission from the creator or agency to use that information. In Michigan, currently, the state does exert copyright over state government publications, so users do need to seek access from the creator to utilize state government information for purposes other than personal and non-commercial use. Because of this lack of understanding, state government is not always responsive or effective at clearly and procedurally addressing requests for copyright. This makes it difficult for potential users to get the agency's attention or even to locate the correct contact point within the agency because it's not perceived as a high priority or even necessary to respond. I also wanted to talk a little bit about the perspective of the state library within state government because they occupy a unique and potentially conflicting position with state government copyright policies. At the Library of Michigan, as with many state libraries, we have a statutory responsibility to collect, preserve, and provide access to published state government information. Unfortunately, the statute does not address copyright, and current copyright policy in Michigan could be interpreted as limiting some of the activities LM pursues in preserving and providing access to electronic and digitized state government publications. Despite this, we have forged ahead under the belief that state government information should be exempt from copyright, and we have constructed a digital preservation platform that provides free, unfettered access to digitized and born digital state government information. Through our relationship with the Hadi Trust, we have, as Justin mentioned, signed permissions to open Library of Michigan and Michigan State Library works that are still protected by copyright. And we also plan to use our insider state government knowledge and influence to facilitate Hadi Trust's efforts to acquire additional permissions to open copyrighted Michigan government works. We believe that we are operating within the limitations of the current state government copyright policy by pursuing these activities. So I hope this information maybe strikes a chord and is something that is relevant to your state as well. And Chris, do you follow up?
So I'm going to jump in here. We're going to go over a few possible avenues forward and potential solutions. In the course of the next few slides, I'm going to address permissions agreements with state agencies, and then the idea of a state government license, and finally the possibility of legislative change. And then Bernadette will then go over issues related to state government documents and executive authority. So the first option that I'd like to go over is for individual state agencies to sign permission forms allowing digital libraries like Hadi Trust to make state documents available through the digital library. And this option is currently available, and I'd urge you all to consider it, everyone in this audience to consider it. We all consider this as a potential catalyst for states to get more involved in this issue. That said, we also recognize that this is a shorter-term solution to a long-term problem. But that said, if you're interested in pursuing this option, I know Bernadette and Chris would be very happy to speak with any of you who are interested.
Yes, most definitely.
The next option that I'd like to talk about with an eye to the long term, states could consider exploring Creative Commons licenses or state-specific variations which define the rights the state wants to retain in state author documents. And you probably didn't see it at the very beginning, but Chris has applied a Creative Commons attribution non-commercial license to this slide presentation. And so future users of this slide presentation would be free to share or adapt the slide presentation so long as they provide attribution and don't use the work for a commercial purpose. And I would think that conceivably there are state agencies that would be interested in this particular licensing regime. For example, some states may recognize that digital libraries are a great means of preserving and providing access to their state government documents, but at the same time they may be concerned that a competing commercial publisher might exploit state-produced documents and undermine contractual relationships between the state and its publishers. In that case, a Creative Commons attribution non-commercial license might be appropriate, and it would allow a digital library to provide long-term access to the work, but it would also preclude a for-profit publisher from printing and selling the work. And then the final option I'd like to go through is just this idea of legislative change. All 50 states could consider something like Section 105 of the U.S. Copyright Act. And I'll say again that I think Section 105 is really elegant in its simplicity. And I make no claim to be skilled in drafting legislation, so I've made no attempt to offer up a model state statute. With that said, I hope that you might reflect on these ideas, whether now or if you download this slide presentation later, and consider them as you discuss this issue amongst yourselves and with others who are interested in this topic. I want to highlight that, from my perspective, statutory language that refers to copyright explicitly rather than public information is really important in terms of clarity for us. So that would be an element that I would really want you to consider. And then the last bullet point, state legislatures could consider imposing a notice formality on state agencies. So really require that the state agencies be explicit about those works that they want to claim copyright in, and that would provide us with notice and would be, I'm not sure if, Chris, Bernadette, do you hear me?
Yes.
Okay,
yep,
sorry.
There.
Sorry about that. I thought that I might have gotten bumped. You know, it would provide clarity to us because we would know when a state agency really wants to claim copyright in a given work, and it would provide clarity to users in general. And now I'm going to pass it back to Bernadette, and she's going to go over some slides regarding executive authority.
Okay. Again, I want to give the disclaimer that I am talking about executive authority from a Michigan-specific point of view, but I do believe that there are similarities across state governments, and that this is a possible avenue of exploration for all state governments to look at working with copyright policy and law. The top of the heap in executive authority here in Michigan is the executive order, which is a formal instrument that exercises the power granted to the office of the governor under Michigan's Constitution. The governor uses these orders to reorganize state government, reassign functions, and regulate conduct within the executive branch. They do attain the force of law, so are potentially useful as a tool to establish copyright law, but they have limitations. EOs can be overturned by the legislature and amended or rescinded at will by current and future governors. Most limiting for the purposes of establishing a government-wide law or policy regarding copyright is that their authority extends only to the executive branch. The legislative and judicial branches are not compelled to comply, which makes them less viable as a long-term or permanent solution. Executive directives, like orders, are issued by the governor, but they have no legal authority under the Constitution. Generally, they're issued as a method for instituting new policy within the executive branch or a specific agency. Because they don't carry the force of law, they're, to my mind, even less stable than executive orders, but they have been used in the past to declare gubernatorial support for statutes that require action on the part of state government entities. And the example I have for this is when the Library of Michigan Act was passed in 1982, it included a section on our state government documents depository program that required agencies to send us 75 copies of all of their publications. And the governor at the time issued an executive directive directing state agencies to comply with that section of the law, which we used for a number of years as an influencing tool, shall we say, with state government agencies to get those materials we needed. In fact, we probably used it far longer than it was really viable, because I don't know past his administration how much weight it carried. Executive directives can also be rescinded and reissued at will by current and subsequent governors. And to my knowledge, there have been no executive orders or directives issued that deal with copyright or intellectual property rights of published Michigan state government information. The next level of executive authority is administrative law, which provides two possible routes: promulgating rules or regulations and seeking an attorney general opinion, both of which have inherent challenges, but they're avenues worth exploring. The definition of a rule in Michigan includes the term regulation, so I've lumped them together, but both are likely to address procedural and technical specifics in support of state statute. Rulemaking is a time-consuming process, and it can be adversely affected by whether the agency is perceived as having the right to promulgate rules on a specific question or issue. Ultimately, it also requires legislative approval. On the plus side, it does give the agency the opportunity to enter into law a policy or procedure crafted from the agency's point of view. The other thing I was going to mention were Attorney General opinions. The Michigan Attorney General's role is to address questions of law for state government entities and officers. These opinions provide legal insight as to how agencies can interpret existing laws and rules. AG opinions do not carry the weight of statute or court decisions, but they are viewed as strongly persuasive and have authority in the absence of that higher level of guidance. An AG opinion on existing statute that addresses state government information and IP rights could be informative and useful in establishing how researchers, libraries, and digital repositories can use state government information. It should be noted that a query to the AG would need to be well crafted, and that the inquirers should be prepared to deal with the consequences regardless of the outcome of the opinion. And lastly, I want to talk a little bit about policy. Policy established by state government agencies does not carry the force of law per se, but is usually supported by authority given to the department or agency to carry out the requirements of Michigan statutes. Based on my research, I find that information issued by policy is often difficult to locate, ambiguous, sometimes conflicting, and very fluid. However, it is the primary method by which Michigan exerts copyright over state government information. The primary source for copyright policy within the executive branch since 2001 takes the form of a copyright notice and links to a terms of use policy that is included on every michigan.gov webpage. The policy doesn't mention copyright specifically, but asserts protection under intellectual property laws. It basically states that Michigan government information is intended only for personal, non-commercial use. The statement then directs users they may want to use the information for otherwise prohibited purposes to contact the state. And I put contact the state in quotes because unfortunately there is no associated procedure or directory of contacts to help the user accomplish this. It's just kind of a dead-end statement. In addition, this policy includes a statement that the state has the right to amend the terms and policies from time to time. My research has shown that while the intent behind the policy may not have changed, the strength and specificity of the statement has definitely increased over time. The websites associated with the judicial and the legislative branches have different and less specific copyright statements and policies, so I basically just concentrated on the executive branch for this. Another source of copyright policy are manuals, which are compiled at various levels within the executive branch, some dispensing guidance unilaterally to all executive branch departments, and others applying only to specific agencies. I've found copyright-related statements and policies in these types of manuals, but they are, as I mentioned, fluid in nature. They appear and disappear over time and occasionally provide conflicting information, further contributing to the ambiguity of copyright policy within the executive branch. based on what I've learned so far through this research, I do not necessarily see executive authority as the best solution to issuing new copyright law because of the limitations and challenges I've mentioned here. However, I do see potential in Michigan executive authorities as tools to facilitate compliance within copyright law, within the structure of state government, and to educate employees on copyright policy, which I think is a very definite lack within state government. And I would be very interested to see if other states have different authorities and approaches within their executive branches that could prove stronger or more all-encompassing in copyright law, in establishing copyright law. And to finish up, Chris?
Yep, I'll jump in. So we want you to get to know us, the Free State Government Information Collective, and the URL that's up here on the slide is the best way to get in touch. If you notice, we didn't have our emails in the slides at any point. We're hoping that people will come and interact and discuss and talk to us using our FSGI platform. And so just briefly to introduce FSGI, our goals are awareness campaigns, so that's what we're doing right now. We're hoping to potentially develop maybe model legislation if that is a good option for states. We really want to collaborate with state agencies, provide support and assistance to them if they're wanting to take on this challenge to clarify copyright within their state, and just make change happen on this issue. And lastly, I want to point out some ways that you can participate even now. One, we did send out a survey, and if you haven't already done so but would like to do so, you can still take that survey, respond to it. It is up on our Free State Gov Info website. If you just go to that website, it should be on the very front page, or you'll see it on our blog roll on the right-hand side. It's still open, so you can go ahead and respond. You could join our working group that we're trying to assemble that will be determining the feasibility of these options and solutions we've presented, or find out if there's other solutions and ways forward. If you want, please post or discuss issues that are on FSGI. Consider being a contact and conduit for change in your state or at your state agency to advance this cause, and please provide input and feedback to us. So just wanted to say thank you for letting us present to you all. We really appreciate it. This is a great group to get this issue out in front of. And with that, we're going to go ahead and wrap up and move into questions, answers, and discussion.
Thanks, everyone. For anyone who has a question, please type it in the chat box on the bottom right-hand side of your screen. And we already have one question, so I'll go ahead and read it. And it says, has the Uniform Laws Coalition ever been involved in drafting a uniform law states could use?
You want to go ahead, Justin?
I mean, I'll say from my angle, not to my knowledge, but I also think that there may be someone in the audience that might have some knowledge on that too. And Chris and Bernadette, if you have a knowledge of that, that'd be great to know.
Sure. There's they've made one inroad to this, and it's under UELMA, which is the Uniform Electronic Legal Materials Act. And so they do have, and I believe that may actually be posted in our bibliography, and if it isn't, I'll get that up on our website. And so that's looking at legal materials specifically, and they've defined it quite narrowly, so it's looking really just at codes and statutes. It doesn't include legislative materials, but it's a first step into drafting uniform law for states. And I know California has adopted it, and I believe at the last check there were, I think, maybe 2 other states that had adopted it. So yes, that is one area that we're kind of keeping an eye on and seeing, you know, if that would be the route to go. So thank you for asking that question.
I have another question here. It says, for those of you who filled out the survey, have any of your ideas regarding copyright and state government documents changed over the course of this presentation?
That's a question back out to our audience, if you wouldn't mind chatting in and giving us some feedback on that.
So anyone else have any questions or comments?
I do see the code. I do see the comment regarding Virginia Code section 2.2-3822, and I will be looking at that after this conversation. So thank you very much for sending that, and I'd be interested to hear any other similar statutes out there.
And that comment is Virginia Code 2.2-2882 addresses copyright including Creative Commons. Another question for our audience is from the options and solutions. Do any of you have thoughts on the feasibility, or would you be interested in pursuing further this topic in your states?
And again, that's a question out to everybody in the audience. And if it's easier for you to think about that and send us a reply, you can definitely do that through the FSGI website.
There is another question on here about asking for examples of states having a problem with someone using their material. And I have an example from a few years ago. There was a user who went to a state agency website and they pulled off some documents from their website and repackaged them and were basically selling them on their own website, which, you know, the commission that they pulled them from was offering that information for free. And so that commission called the Attorney General's office to find out, well, what can we do about this, because this person is trying to sell this information. And I don't know exactly what the outcome was, but I actually received a call from the AG's office wanting to know my opinion on copyright of state government information in Michigan, which I thought was really an interesting approach from the AG's office. So, you know, that's just one example of how sometimes that lack of clarity in copyright policy or law within a state can cause problems for agencies because they don't really understand it or know how to respond or what their options are.
And then just to chime in on that too, from the academic institution perspective, while there haven't been any court cases that have been brought against a particular institution that we've been able to find, the risk is still there. And so in doing risk assessments, it's typically not something that a lot of institutions want to put themselves up for a potential lawsuit. And so the easiest way to accomplish that is by going out and seeking the permissions. And that's not necessarily a bad thing, but as you can see, it's very difficult, it's very nebulous, and very ambiguous. And so having better clarification and also working with the principle that most people do feel that this material should be in the public domain, or they should have clear guidelines as to how they can use it, is important. And so a lot of this is just operating on the potential threat of legal action.
We have another comment here. It says the UELMA does not address copyright restrictions on legal materials, explicitly leaving those issues to federal law and state practice. See the Attorney General, see the prefatory note to the Uniform Act, and there's a website which will get posted.
Right, and so states have to adopt. That's my understanding.
Here's another question. Have many academic libraries used the agreements to clarify copyrights of digital state government information?
Let's see. Can you reread that for us, Sonia?
it says, have many academic libraries used the agreements to clarify copyright of digital state government information?
Well, so the agreements that we showed, that's actually something that the state agency needs to sign. So that agreement that Justin showed from HathiTrust, I've actually given that to state agencies when I was seeking permission to encourage them to use it. And I'll be honest with you, a lot of them are very hesitant to sign that type of a permission agreement, which is why we have slightly scaled back email language that we send out. And I think part of it is, as Bernadette has shown you, is an education and with agencies and having that dialogue to have them understand. And I mean, I get it from a state agency's perspective. When they get handed something like that, they're going to need to consult with their general counsels to find out, do they have the authority to sign something? So again, that's why we see those agreements as being a short-term option, especially for states that are willing and able to sign that type of document.
Great. A couple more questions. Let's see here. How does non-consumptive or data mining use figure in? What assumptions are people operating on out there?
So I'll take a stab at that question, but the assumption that I'm operating on to some degree in talking about these are the artifacts, the scanned digital copy of a work that was published in the past. So that is something that I'm focused on in this presentation. In terms of the data mining possibilities, I'm much more concerned with whether or not a digital library like HathiTrust can make the scanned copy available for which a user could decide what they want to do with it, including gathering information from it.
Right. So it's being able to just open up the material in the first place to enable data mining.
Another question we have here is any recommendations on getting permissions from agencies that no longer exist, either through decommission or merger with another agency? That's a great question.
Yeah, that is. And thank goodness I haven't yet had to deal with that one, but I know it's lurking out there, given what I know of the researchers I'm working with. And so that approach, I would probably have to find out, if it was merged or what agency would have the authority at that point. And so that's something that I'm going to have to figure out how to deal with that. Most likely I would have to sit down and have a conversation with our legal folks here to see what they're going to require of us, require of me to do with these agencies. But most likely that will be a long journey of trying to tease that out and figure it out and get the right person and then have that conversation and send them that email. So that's one of my fears, honestly, whoever asked that question, because it's going to happen.
Great. I don't see any more questions right now. Would you guys like to do a closing comments?
This is Bernadette. I'm sorry I muted myself a few minutes ago. I wanted to, the recommendation question on getting permissions from state agencies that no longer exist. You're just going to have to employ persistence. And also, I would put a plug in for your state library, because I'm sure there is somebody there who has a lot of knowledge about how state government has, how the structure and the ownership of state government function has moved and been reassigned over time. So those are going to be really good resources for determining who you should be talking to and also making contacts within those state agencies.
That's a great point, Bernadette. I know in the various projects I've helped out, often that's where we start, is with the state library to find out that information. Or in some cases, they're able to, for different publications or items, they're actually able to tell us what the nature of copyright is, or give us permissions even.
and that's some of the assistance that we're planning on giving HathiTrust in Michigan to continue to open up the Michigan state government documents that are in copyright at this time.
We have no more questions, and our time is almost up, so I'd like to thank our speakers and wish everyone a good afternoon.
Thank you. Ladies and gentlemen, this does conclude today's teleconference. We thank you for your participation. You may disconnect your lines at this time, and have a great day.